Federal children. Are we owned by the government? In 1921, the Federal Shepherd-Towner Maternity Act created the birth registration, or what we now know as the birth certificate. It was known as the Maternity Act and was sold to the American people as a law that would reduce maternal and infant mortality, protect the health of mothers and infants, and for other purposes. One of those other purposes provided for state agencies in overseeing of its operations and expenditures. What it really did was create a federal birth registry, which exists today, creating federal children. This government of parents patriae now legislates for American children as if they are owned by the federal government. Through the public school enrollment process and continuing license requirements for most aspects of daily life, these children grow up to be adults indoctrinated into these things necessary to carry out our activities that exist in what is called a free country. Before 1921, the record of birth and names of children were entered into the family Bibles, as were the records of marriage and deaths. These records were readily accepted by both the family and the law as official records. Since 1921, the American people have been registering the birth and names of their children with the government of the state in which they are born, even though there is no federal law requiring it. The state tells you that you are registering your child's birth through a birth certificate serves proof that he or she was born in the United States, thereby making him or her a United States citizen. For the past several years, a Social Security number has been mandated by the federal government to be issued at birth. The Social Security number is one of those other purposes. It serves as a means of a lifelong tracking of those whose names is on the birth certificate. In 1933, the United States of America corporate government was declared bankrupt by President Roosevelt. The governors of the then 48 states pledged the full faith and credit of each of their states, including the citizenry as collateral, for loans of credit from the Federal Reserve System. To wit, full faith and credit, the clause of the U.S. Constitution, Article 4, Section 1, which provides that the various states must recognize legislative acts, public records, and judicial decisions of the other states within the United States. It requires that foreign judgment be given such faith and credit as it had by law or usage of states of its origin. The foreign statutes are to have force and effect to which they are entitled in home state, and that a judgment of record shall have the same faith, credit, conclusive effect, and obligatory force in other states as it has by law or usage in the state from whence taken. See Black Laws Dictionary, 4th edition and 6th edition, page 672. Cites omitted. After receiving the information of live birth and other particulars for the birth certificate accompanied by the assigned Social Security number, the state claims an interest in every child within its jurisdiction. The state will, if it deems it necessary, nullify your parental rights and appoint a guardian, trustee, over your children. The subject of every birth certificate is a child. The child is a valuable asset which, if properly trained, can contribute valuable assets provided by its labor for many years. It is presumed by those who have researched this issue that the child itself is the asset of the trust established by the birth certificate, and the Social Security number is the numbering registration of the trust, allowing for the trust assets to be tracked. If this information is true, and we believe it is, our children are owned by the state. Each one of us, including our children, are considered assets of bankrupt United States corporation. And as we know, my child does not have a birth certificate, but again, I'm going to continue reading. We are now designated by this government as human resources, born in a delivery room, delivered to the state of birth by way of birth certificate, for which our informer, our mother, provides the requested information, including the name and social security or tracking number, wherewith this bankrupt government is supplied with a new crop of collateral born each year. In 1923, a suit was brought against federal officials, corporation, charged with the administration of Maternity Act, who were citizens of another state, to enjoin them from enforcing it, wherein the plaintiff averred that the act was unconstitutional and that its purpose was to induce the states to yield sovereign rights reserved by them through the federal Constitution's 10th Amendment and not granted to the federal government, and that the burden of appropriation falls unequally upon the several states, held that as the statute does not require the plaintiffs to do or yield anything, and no burden is imposed by it other than that of taxation, which falls not on the state but on its inhabitants, who are within the federal as well as the state taxing power. The complaint resolves down to the naked contention that Congress has usurped reserved powers of the states by the mere enactment of the statute, though nothing has been or is to be done under it without their consent. Commonwealth of Massachusetts versus Melton, Secretary of Treasury. Frunton versus Mellon, Secretary of the Treasury. Mr. Alexander Lincoln, Assistant Attorney General, argued for the Commonwealth of Massachusetts, to wit, number 1, the act is unconstitutional. It purports to vest its agencies of the federal government, a corporation, powers which are almost wholly undefined in matters relating to maternity and infancy, and to authorize appropriations of federal funds for the purpose of the act. Many examples may be given and were stated in the debates on the bill in Congress of regulations which may imposed under the act, the forced registration of pregnancy, government prenatal examinations of expectant mothers, restrictions of the right of a woman to secure the services of a midwife or physician of her own selection. All are measures to which the people of those states which accept its provisions may be subjected. There is nothing which prohibits the payment of subsidies out of the federal appropriations. Insurance of mothers may be made compulsory. The teaching of birth control and physical inspection of persons about to marry may be required by the Section 4 of the Act. The Children's Bureau is given all necessary powers to cooperate with the state agencies in the administration of the Act. Hence, it is given the power of assistant in the plan submitted may provide. As to what plans shall provide, the final arbitrators are the Bureau and the Board. The fact that it was considered necessary in explicit terms to preserve from invasion by federal officials the right of the parent to the custody and care of his child and the sanctity of his home shows how far-reaching are the powers which were intended to be granted by the Act. The Act is invalid because it assumes powers not granted to Congress and usurps the local police power. That's Macaulay versus Maryland. In more recent cases, however, the court has shown that there are limits to the power of Congress to pass legislation purporting to be based on one of the powers expressly granted to Congress, which in fact usurps the reserved powers of the states, and that laws showing on their face detailed regulations of matter wholly within the police power of the states will be held to be unconstitutional, although they purport to be passed in the exercise of some constitutional power. That's Hammer versus Dagenhart. The act is not made valid by the circumstances. The federal powers are to be exercised only with respect to those states which accept the act, for Congress cannot assume, and state legislators cannot yield, the power reserved to the states by the Constitution. A message of President Monroe, May 4, 1822, for Elliott debates. And as you see, that just lists more case law. And I will continue reading. Number 2. The act is invalid because it imposes on each state an illegal option either to yield a part of its powers reserved by the 10th Amendment or to give up its share of appropriations under the act. A statute attempting, by imposing conditions upon a general privilege, to exact a waiver of an unconstitutional right is null and void. Now that's Harrison versus St. Louis and San Francisco. San Francisco, that's where I was raised. Number 3. The act is invalid because it sets up a system of government by cooperation between the federal government, a corporation, and certain of the states, not provided by the Constitution. Congress cannot make laws for the states, and it cannot delegate to the states the power to make laws for the United States. And as you see there, more case law. I'm going to scroll down. And we have here the Maternity Act. The Maternity Act was eventually repealed, but parts of it have been found in other legislative acts. What this act attempted to do was to set up government by appointment, run by bureaucrats with redelegated authority to tax, which in itself is unconstitutional. What was once declared unconstitutional by the Supreme Court of this nation in the past should be upheld in the court challenge today. The Constitution has not changed. What has changed is the way this government views human life. Today we are defined as human resources, believed to be owned by the government. The government now wants us, as individuals, to be tagged and tracked. Government mandated or legislated national ID, which is unconstitutional. Federal jurisdiction to legislate for the several states does not exist and could never survive a court challenge as shown above. Writing letters to elected public servants will not save us, when we all know their agenda does not include serving those who place them in power. Servitude. Perhaps the 10th Amendment of the Federal Constitution guaranteeing states' rights will, if challenged, when making it known that we as individuals of the several states will not be treated as chattel of the U.S. government. If the federal government believes that they own us and as such have the right to demand national ID cards and health ID cards, which will in truth tag us as we tag our animals, then let them bring forth the documents to prove their authority to legislate for it. If our God-given rights to life, liberty, freedom, and pursuit of happiness, which were the foundation upon which this nation was created, do not exist, and liberty and freedom is only an illusion under which the American people suffer, then let the government of this nation come forward and tell the people. But if we are judged free, then we should not have to plead or beg our elected public servants to be treated as such. If in truth we are not free, then perhaps it is our duty to address this issue forthright and forthwith with the power of the pen, and pray that the people will awaken from their fear and slumber induced by greed.